Welcome, everyone. Thank you for joining today's webinar. Our speakers include Jeff Tenenbaum, who is a managing partner at Tenenbaum Law Group, and Mike Hayes, who is a principal and managing director at Vault Consulting. They will be talking today about association-sponsored research in the antitrust laws, staying out of legal trouble, and protecting your members. My name is Karen Taylor, and I'm head of marketing here at Vault. I'll be monitoring the chat and also sending out the recording once this is finished. Without further ado, Mike.
All right, thanks, Karen, and hi, everyone. As Karen mentioned, please feel free to use the chat. Any questions you can think of as we get started. Jeff, I know, will not be shy, so I expect him to have questions as I'm talking, and I will do the same to him. I'm going to kick things off, and the way we have this split up, I'm going to go first and talk about some really best practices that really cover any research program. And when I say research program, what we're really talking about are programs that are designed to help your members measure their performance and industry trends. So whether it's global manufacturing corporations, lawyers, or individuals within some society, professional society, or doctor's offices, really the same traits that make those programs successful apply across the board. So that's what I'm going to start out with and get into some just general best practices before turning in and a few other background slides, and then before turning it over to Jeff. So yeah, really the first one I think that's important is really know who your competition is out there, and really if there are other sources of information and data available for your industry. That could come in many cases, whether it's another association, maybe your members are reporting information through government sources and there's government data available, and maybe there's well-known industry consultants in your field. But really know what that is and what is your value proposition. For example, are people in your industry and your members turning to you for the more detailed report, or do they get that elsewhere, and what they're looking for you is something that's very timely and quick that can be, whether it's monthly or more frequent compared to other sources of data. And that really should be factored into any type of program that you're doing. Any type of program like we're talking about, the key thing is this is member driven. This is a big member benefit. Well, I'm sure there's some ancillary benefits that your organization may get from running these types of programs. Again, the key thing we're talking about here is, what can you provide your members with to help them track their specific performance? With that being said, I say member driven, but know your members as well. You may have, let's say, 10 players, and you all know who that one elephant in the room is that you may need to get on board to really make something viable. That's why we always say start simple, especially if you're starting something from scratch. What is that minimum viable product? And that could be in terms of the frequency of how frequently you collect the data. Maybe you're starting quarterly or annual before switching to monthly. And believe it or not, we have some programs that are even weekly. Geographic region as well. Maybe it's a US program to start, and then you switch to worldwide program or more regional specific by zip code level even, and just the number of categories that you're collecting as well. Related to all that, you need to have clear program rules and definitions. When we talk about some of those like compensation reports that track levels for different industries across different pay ranges across different titles, you really need to have clearly defined job titles, so you're really looking at apples to apples when you're looking at those results. Product definitions need to be clear as well. There's a whole plethora of program rules, and that's something that always needs to be defined at the beginning, and a lot of thought and effort to go into those standard operating procedures, again, to ensure that what you're producing on behalf of your members is accurate as well. And that feedback loop is important. Again, this is all these should be member-driven programs, so having regular meetings with your members and the key stakeholders to make sure that what you're producing is still valuable is important. If there's new trends, emerging technology, new products, whatever it may be, make sure you're capturing that. What worked 5-10 years ago probably isn't going to work, what worked 5-10 years ago may not work today and may not work 10 years in the future either. Karen, you can go ahead. And then the next one, the key for any type of program is really you need you could have the best designed program and study, but if you're not getting your members to participate in it, it doesn't really do you any good. Incentives and promotion, typically that entails, the main one, obviously, a copy of the final results of the report. I don't think a Starbucks gift card is going to work to get companies like ExxonMobil to submit their information to some program. So it's really that value proposition of what makes your information and report stand out needs to be at the forefront of it. But with that, maybe I'll turn it over to you, Jeff. Is there any specific, and that's really what we see with incentives and promotion, maybe for some of these like one-off studies, if it's like doctor's offices or individuals, there could be a discount in booth space or some member benefit, maybe entered into a drawing. For manufacturing associations, it really isn't it. It's really the output is the main benefit. But any specific rules or kind of guidelines to have in mind related to any type of incentives?
Not really. I mean, so long as the incentive is fairly nominal, and like you said, this is really not going to work for corporate members, for like industry trade associations, more for maybe professional societies, where we're talking about individuals, where some sort of a nominal benefit, like a gift card or a discount or something like that, that's generally going to be permissible. Anytime you're dealing though with, because you did mention something about raffles or any kind of, once you get into any element and any sort of a structure that involves consideration and chance, meaning that someone has to pay or do something in order to participate in the contest, and then there's an element of chance in terms of who wins, like a drawing from a raffle, something like that, that can trigger. Many states and even some cities and counties have laws governing raffles and lotteries that get really tricky. In some cases, they're absolutely prohibited. In other cases, only certain types of entities can do it. In other instances, you have to get a license to do it. We actually have outsourced gaming counsel that we use, our firm uses quite often for these sorts of situations, and it can get very tricky and very expensive, and it's very state and local specific, especially if you're dealing with a nationwide audience. It can be really a nightmare. So I would stay away from that, from any kind of a raffle or element of chance, but providing a nominal incentive to participate, particularly if it's a discount off an association service or something, is not problematic.
And I think that's what we see the most with those like trade groups. Maybe there's a discounted booth space would be the biggest benefit, or some type of incentive related to that. But no, that's good to hear. And obviously the key thing to get that participation up is starting at the beginning. Make sure this is a member-driven initiative. It's something that members are asking you for and that they will benefit from, and make sure that that you have that promotion of it as well. Before something goes out. It becomes easier when it's an ongoing study that may be well established, but especially for some of these one-off or annual studies, that promotion is really key to discuss how your members and how the industry itself will benefit from these results. Then other things with the response rate, just how can you simplify that submission process? Know what you're collecting. For example, if you're collecting compensation information at an organizational level, make sure you're sending this to the right person. So ideally, that could be an HR contact that you can have at that organization, but give them some flexibility in how they provide that information. We find a lot of times our clients prefer we can create fancy, sophisticated online forms. However, if that means somebody is keying in hundreds of data points or entries, there's room for error, and that can be quite time consuming. So we find a lot of times that if you can give them kind of a way to upload, really to fill out an Excel form, it sounds kind of old fashioned, but putting it in an Excel form, submitting it through a secure online portal can work as well. That allows them to link everything to their own internal files, and that those files can then automatically update, especially if it's an ongoing study, monthly, quarterly, it can update in the future that way as well. The last one, the more sophisticated model, of course, would be building some type of API that your reporting tool could talk directly with the finance systems of members and participants to pull that data directly. That requires that more legwork and setup time. However, that can really speed up the process and is a future member benefit, because just like everyone else, the more automation and easier you can make things, the better for everyone.
Yeah, and Mike, one more thing, and you alluded to this earlier, but just worth reiterating that certainly one of the most important benefits you can offer to increase your response rate and participation is that only participants get the survey data. And I'm going to speak to that a little bit later in the antitrust discussion. But it's certainly permissible in most cases to limit distribution of the benchmarking, the information exchange, the survey, the study, whatever, to participants only. In some cases that doesn't make sense and doesn't work. You all see some very large associations, like home builders and realtors and others that are, they publicize their data. Retailers, big associations that do a lot of survey data and then publish it to the general public, and it's very much relied on by financial markets and others. Limiting that to participants only obviously doesn't work in a situation like that, but there are plenty of other situations where it can be a real incentive to participation.
Right. No, I agree 100%. I would say it's a mixed bag probably with our clients. In a lot of cases, at least for free, it may only be available to participants. And we'll, assuming we have time for it, and we'll get into some additional information about how to potentially monetize data and the results from your programs as well. But right, having that the participants get it for free. And I think as importantly, back to like those program rules and usage, believe it or not, we have some programs where not even the association staff is allowed to see the results. So making sure that it's very clear, if that could be viewed as a barrier to get something started or for companies to participate, make sure that's clear and upfront. The output should have, in the program guidelines, should have those report usage rules as well to make sure that everyone is following. And then the last thing about reports that I want to talk about is really just the output. What are you producing? Again, you could have great member input, a great process to figure out what to collect that's going to benefit your industry. But if the end result is some 400-page PDF report that has hundreds of data tables, you may not get much mileage out of that. So really think through how you present the information. That's just as important. Simple steps, obviously, you can tell when a charted graph has been produced in like Office or Excel 1997. So think about more sophisticated ways you can present results to be visually appealing is helpful. That added analysis portion I like, and we see this in some of our clients and industries where it could be a report that Vault puts together or the industry output that is then either an in-house economist or another group may take that information and kind of and put it in the context of the overall economy, give some future looking trends that may be up or down, how they project the industry to go. And then we've also seen that those types of reports lend themselves well to some forums, whether it's webinars or during in-person meetings. Get the economists up there so members can grill them, ask about industry specific things. But maybe Jeff's flag is going up. There's probably some caveats about how that discussion should go and how that should take place. So I'll turn it over to you.
You were right about that. In general, what you're describing is fine and not an issue. And having, say, an economist who's retained either by your firm or by the association to provide some, additional analysis and commentary and kind of maybe speculation about, where the industry is going and whatnot. In general, that's fine. But because, and I'll talk about this in a few minutes when we get to my portion of the presentation, because an association is a combination of competitors, anything the association does is subject to much more scrutiny under the antitrust laws, particularly the horizontal antitrust laws that govern concerted action by competitors. And so even an economist who's hired by Vault or by the association to provide that sort of stuff, if the economist is, say, for instance, predicting some very sensitive competitive information like where prices are likely going to be, 6 months from now, that could be viewed as the association signaling to its members where its prices should be, and that can constitute price fixing, which is highly illegal, the most illegal thing basically under the horizontal antitrust laws that I'll talk about in a minute. And so you just want to be very clear to that economist or whoever's doing it, make sure legal counsel's involved in reviewing any output before it gets put out there, to make sure you can talk generally about the state of the industry, health, weakness, that sort of stuff, many other aspects, but make sure that whoever is acting as an agent of the association, like in that economist in that example, stays away from anything regarding specific prices or fees or other things like that.
Okay, no, that's good to hear. Where I've seen it be successful and where it can create a lot of interaction is if they really start with that, maybe start macro view, let's say, and what drives the industry. Let's say it's the housing market, starting with that analysis, maybe a general outlook there, and then how it may relate back to the specific industry, or people in the room or in that webinar and how it relates to them. So that's good to hear. I think that's a good way. Just that added analysis piece is something that, again, this is based on the usage rules, but for some of our output, there may be a corresponding press release, and we've seen cases where whether it's somebody on the association staff, a member, somebody provides some added context or analysis. Obviously, there's some caveats and kind of guardrails to go against when they're doing that. However, just putting the results, just saying, hey, the numbers are up 10% this quarter is great, but a little more context around it can often be very helpful. And the last one here, just customization. This is a big one, and it's nothing new at this point, but again, getting rid of that 400-page in-depth report and providing more custom analysis. Obviously, the restrictions there is if I'm a company that's a participant, they're only seeing their information. They're only seeing the industry information. There's rules that Jeff will get into related to. They're not seeing specific categories if there's not a certain amount of participants and rules related to that. But can you create, just interactive reporting dashboards? Power BI, other programs are great at doing that. A lot of those BI tools have that functionality where users can come in and save their specific views. That's also a great opportunity to take that information and, from your members in your specific industry, overlay it like we're talking about with some of these more macroeconomic trends, so you can kind of plot those on the same page. So there's opportunities there, and just really there's a lot of easier and kind of low-tech ways for that customization, whether it's simple market share reports for the kind of financial benchmarking studies, just plotting your organization against similar peer group, either by size, geographic region, specialty, whatever it may be. There's a lot of ways that you can really, again, not make your members go through that full 400-page report, let's say, and they can really see what's apparent and what's most relevant to them.
Mike, did we skip a slide regarding monetization?
Yeah, I think we'll try to do that one at the end. I think some of your stuff is good in context of it. Okay. So I think we threw that one at the end.
I think we discussed that, and I completely forgot about that. My bad. Okay. That was really helpful, very interesting. Thank you, Mike. And Mike will kind of wrap us up at the end with some ideas about how to even further monetize your information exchanges and benchmarking and surveys and whatnot. So what I'm going to talk about are some of the antitrust risks in this area and how to mitigate those risks. For those of you who don't know, I'm an attorney in DC in private practice. I've been practicing law for 26 years, all of it exclusively representing associations and other nonprofit organizations, primarily as outside general counsel, dealing with a very broad array of legal issues. One of those issues, particularly for the association side of it, trade and professional associations, are antitrust issues. I've always done a lot of work in that area, counseling and advising associations, doing trainings for boards and others and staff, and working on issues like these. I've given entire webinars and presentations on association antitrust issues. This is kind of a more narrow sliver, but before we get into this federal antitrust safe harbor, which is directly relevant to the topic of today's program, let me give you a little bit of background and context on how the antitrust laws work here. So I referred earlier to kind of the horizontal antitrust laws. These are the laws like Section 1 of the Sherman Act and Section 5 of the Federal Trade Commission Act and the corresponding laws in every state in DC that prohibit concerted action by two or more competitors that are anti-competitive. And no, we can stay back on Karen on the initial slide. Concerted action by competitors that are anti-competitive. It's a broad, like the sentence in Section 1 of the Sherman Act has been interpreted dozens, probably hundreds of times now by the U.S. Supreme Court to kind of spell out what that means. But essentially, anytime you have two or more competitors, an association is by definition a combination of competitors, that engages in concerted action, meaning they're doing something together. And if it causes competitive harm, it can be illegal under those federal and state statutes. There are a number of different types of kind of horizontal, and by the way, in contrast, kind of the vertical antitrust laws are things like mergers and monopoly power, which we generally don't get into in the association world. But on the horizontal side, because associations are combinations of competitors, so they already meet one of the requirements of a potential antitrust violation, associations have long been targets for enforcement and litigation at the federal level by the U.S. Department of Justice Antitrust Division and the Federal Trade Commission, and at the state level by state attorneys general. And then while the FTC Act doesn't have a private right of action, the Sherman Act certainly does, as to many of the state laws. So individual competitors who are, say, harmed by an antitrust violation can bring litigation as well. And under the Sherman Act, they can receive what are called treble damages, triple damages, plus attorney's fees for many violations of the antitrust laws. So they're really serious laws. They pose a lot of risk. They're regularly enforced. Associations have long been targets for enforcement. There are different types of antitrust violations that we deal with in the association world, things like a group boycott. Like, for instance, a member is kept out of the association for a variety of reasons, or is expelled from the association, or is denied certification or accreditation by the association. This can give rise to group boycott claims. Bid rigging, where two or more competitors are rigging bids. Market allocation, where two or more competitors are allocating the market between them. I'll only do business in this territory, or in this type of business, I'll only do business in this territory, or this type of business. That's highly illegal under the antitrust laws. But the most serious violation of the horizontal antitrust laws is price fixing. And that's when two or more competitors agree on prices or fees to be charged. It's the most serious. There's two different types of antitrust violations: per se violations and violations that are analyzed under the rule of reason. The per se violations are the most serious because what they say is that in price fixing is the most serious per se violation. What the courts have said is that if you engage in price fixing, it doesn't matter if it even has a benefit to consumers, even if competitors are agreeing to lower prices. It's highly illegal. It's an automatic per se violation. Doesn't matter the rationale. In the rule of reason, you're balancing pro-competitive justifications against anti-competitive harm. That doesn't exist when it comes to price fixing. So because it's so serious, it's so risky, the most dangerous antitrust violation, associations need to go to great lengths to protect themselves from unwittingly tripping over any price fixing allegations. And because information exchanges, like the kind that Mike was talking about and like we're focused on today, can be and have been used as tools, to signal to competitors, here's where we should go as an industry on prices going forward. Because of that, these have always been deemed to be very risky from an antitrust perspective. Now, with that as background, I'm going to talk about this federal antitrust safe harbor for association benchmarking and information exchanges. And Karen, if you can advance to the next slide, that would be great. So in a joint statement that was released by the two leading federal antitrust enforcement agencies, the U.S. Department of Justice Antitrust Division and the Federal Trade Commission, originally back in the 1990s, but most recently reiterated in a statement that came out in 2000. They came out with this what it called antitrust guidelines for collaborations among competitors. It was targeted at the healthcare industry, but DOJ and FTC said that it definitely has applicability outside the healthcare context. And what the guidelines are, they create a safe harbor, meaning that if you follow the guidelines in this safe harbor, then DOJ and FTC, and frankly, by extension, state AGs and courts in terms of private litigation, will presume that you're doing this safely and that it's not a violation of the antitrust laws and that it doesn't constitute price fixing. And this is an important point. Just like any safe harbor, just because you're in the safe harbor, I mean, if you're in the safe harbor, you're safe, obviously, right? If you fall outside the safe harbor, it doesn't mean it's a price fixing violation or it's an automatic antitrust violation of any kind. It just means it's not going to be subject to the safe harbor. It's certainly going to have more risk attached to it, no question. And, you know, as Mike and I talked about previously, you know, there are certain clients of vaults where they purposely decide that one aspect of their information exchange is not going to be within the safe harbor because it just doesn't make business sense to do so, or there's a need to do something that doesn't neatly fit within the safe harbor. And that's okay. Always make sure, especially if you're going to fall outside the safe harbor, that you have, you know, experienced association antitrust counsel involved in advising you and making sure that you're not unwittingly tripping over any potential antitrust violations. But to the extent you can stay within the safe harbor, it really makes a lot of sense to do so. And one of the kind of core elements of the safe harbor is a principle that I'll talk more about in a second, which is that you don't want industry participants, like in your case, members of your association, to be at all involved in the collection of the data. So I say here, have a third party manage the process. The guidelines, the safe harbor guidelines, say that one a third party that can manage the process is an industry trade association. Of course, other third parties can be companies like Vault, which do a great job. So in this situation, you typically have an industry trade association that's hiring Vault Consulting to be the third party to manage the process. But the key is whether it's association staff doing it or whether you're outsourcing it to a company like Vault, not having the actual industry participants be involved in that process. They're the ones supplying the data, but the collection of the data, the review of it, the sorting of it, everything else to create the final reports should be done without the participation of the members of the association. Next slide, please, Karen. So that's kind of prong one of the safe harbor. Prong two is make the data available. As I say here, it's generally advisable for an association to make its survey results and other industry research available to both members and non-members, but at least make it available to the members that participate in the survey collection. So that's why I was saying earlier that can be a big incentive in certain information exchanges for members to participate if they can get the survey data. There is no obligation to make it generally available to the public, to non-members or whatnot, but you definitely want to at least make it available to the members that participate. Mike,
yeah, Jeff, related to that, we have some groups where, yes, let's say it's available to everyone, but it could be members or participants get it on day one and then 30 days later, or it's more of a staggered release to everyone else. Anything specific?
That's fine, absolutely fine. Also, if you wanted to make it available for free to participants, but charge non-participants, you can do that. All of those are acceptable. Yeah, next slide, please, Karen. All right, this is really, really important. You know, all the prongs of the safe harbor are important, but to me, this is kind of first among equals. And this is absolutely key. And there really should, in my opinion, should really never be any exceptions to this rule. And that is that stick to prior data only. What the DOJ and FTC said in this kind of antitrust safety zone is that particularly where you're talking about wage or price surveys and wages like salaries and compensation and things like that, because there's such a significant factor in prices and can factor into the setting of prices, the antitrust enforcement agencies kind of view wage information the same as they do price information for purposes of potential price fixing allegations. So anytime you're doing wage or price surveys, you should only ask about wages or prices that were charged at least 3 months prior to the date that the participants complete the survey. So all data should be at least 3 months old. It's a really, really important point. If you ask about current prices or wages, And certainly if you ask about future anticipated prices or wages, it becomes very, very risky because that can be viewed as a signal to members, to industry participants, as to what prices they can charge in the future. So again, doing something like this, even asking about future prices, doesn't automatically create an antitrust violation. But if an aggressive plaintiff's lawyer or an antitrust federal state enforcement agency wants to bring an action, they're going to look to that, and that's going to be some pretty significant evidence that they can use to potentially build a case for a price fixing allegation. So stay away from current and future price information and wage information, and ask only about data that's at least 3 months old.
Just one question related to the 3 months old. So I'll throw an example that I know of. So we know some industries where they may report information weekly, slightly more detail monthly, and then even more detail quarterly. However, I think their way to address this issue is that the weekly and the monthly are unit information only, and then they only provide that dollar information that would have that pricing and cost per unit on a quarterly basis. So is that, again,
so that price information is at least 3 months old when they're doing it. It doesn't matter how frequently, but as long as they're doing it that way, that's fine. And if we're talking about non-wage or price information, or at least other data that is not a significant factor in setting prices or fees, then it's going to be much less risky. And this is not going to be, it's not going to be critical to do that. So if you were asking, I know you have a better idea, Mike, of good examples, but let's say just overall sales information, right? That from which that data you would have no way to figure out what prices are. That's going to be far less risky from an antitrust perspective, because none of that data can generally be used. Now, if it could be used to help figure out future pricing or something, that's a different story. But generally speaking, that's not going to be an issue. So if you were asking for sales information that's only a month old as opposed to 3 months old, that's probably going to be fine under the antitrust analysis.
And I think that's the example I'm talking about, where it gets much more granular to include the price information only on that quarterly basis, again, with information that's 3 months old. So the stuff that's done in the interim and that's produced and published is more top level information, or it doesn't have any pricing information, just kind of unit volume instead. So,
okay,
good to hear. Excuse me.
Karen, did you say there's a question for me?
Yes, the question is, are you aware of any recent or ongoing DOJ, FTC enforcement actions against trade association information data exchange, relevant takeaways or implications?
I'm not aware of anything recent. Look, to be frank, especially at the federal level, there's not a lot of federal antitrust enforcement against associations. There are a number of cases in the past. In fact, I remember when I took antitrust law in law school, I remember I was so interested because there were so many cases involving associations, and some of them did involve information exchanges and whatnot. In recent years, there hasn't been a lot, but don't let that provide you with a false sense of security and somehow facilitate some unreasonable risk taking or whatnot, because the antitrust enforcement agencies, both federal and state, can be very aggressive. And just because I can't point to any recent or haven't seen or heard of any recent cases, first off, it doesn't mean it hasn't happened, because a lot of times, there are settlements that don't involve a press release at the end or in any court filing or whatnot. And so sometimes enforcement happens and we don't know about it. But regardless, it should not affect your decision making, your risk taking, things like that. And especially because the antitrust laws can be enforced by private plaintiffs in litigation. It's not just enforcement agencies we have to be concerned about. All right, next slide, please, Karen. This is also very, very important. So what the DOJ FTC guidelines say for the safe harbor is that for any price or wage related information, again, same thing I said earlier, if it doesn't involve price or wage information or other information that is a factor in pricing, but if it involves price or wage information, you want to have at least 5 different competitors, in this case members, participate in that collection. Obviously, you're going to ideally want more than 5, but you want to have at least 5 in every category. And the agencies say that information disseminated needs to be sufficiently aggregated so that it does not allow recipients to identify the prices charged or compensation paid by any particular company. So at least 5 participants, sufficiently aggregated so you can't identify any specific company's prices or wages. And they say you should have at least 5 participants per category, and no participant's information should account for more than 25% of the total in that category. So again, that's the safe harbor. That's what you want to try to get to in every situation, because it's going to mitigate your risk significantly. If you're not within that, say for some particular category, you should never be in a situation where you're identifying individual competitors' prices or wages. But let's say in one particular category, one company's data did comprise more than 25% in that category. That doesn't automatically mean you're going to have some antitrust violation, and you're likely not. But you definitely want to try to stick within this to the greatest extent possible.
And that kind of speaks towards getting full industry participation is huge. That can help with some of and mitigate some of the risks related to these rules. I guess I have 2 questions related to this. The first one, so as you said, I don't think the research practice within Vault probably would not exist if all of our clients followed these rules to a T. So we know clients will review this and they will come up with their own set rules. But then what's the frequency or ideal frequency that they will revisit those rules, and what would maybe drive them to make changes? Let's say instead of 25%, they're okay with 50% or 60%. How often should that be revisited, and why would they?
I mean, I don't have any hard and fast guidance on this, but I would say in general, you all, as an association, you always want to try to be striving to stay within the safe harbor. And if you're going to make exceptions, try to do it on a limited basis. And only, I would try to basically say, in general, our rule is that no participant's information should constitute more than 25% in that particular category. But in certain situations, we may be willing, we may need to or want to make an exception. I would kind of couch it in that way. Like everything else, you should always be revisiting your rules of participation and everything else too. And not so much from a legal perspective, but more to facilitate maximum participation, make sure you're getting the most mileage out of this, everything else. But anyway, I hope that helps.
No, I think that's helpful because I guess related to this, we had a client of ours recently revisit their rules because their program expanded so this to me would be a reason to revisit it. It went from a US based program to an international program.
Of course.
So in cases like that, it should be revisited, and then I'm sure it could be a whole nother session of international laws and additional rules to consider there as well.
Yeah, no, it's true. Like for instance, the EU, European Union, is very aggressive in enforcing antitrust laws. Their antitrust laws are generally similar to ours, same basic principles. I don't believe this safe harbor exists in the EU laws, but following this US federal safe harbor certainly would be very helpful in mitigating risk in the EU. But there's no question that there's all sorts of additional rules in the EU, maybe one of the most notable being GDPR, the privacy regulation over there, which can definitely come into play for some of this stuff. And absolutely, if you're expanding internationally, you're going to want to revisit your rules. You want to have a knowledgeable legal counsel involved in advising you, etc. Okay. Next slide, please, Karen. So this is actually not one of the 5 prongs of the safe harbor, but it's one that I added because it's really important. And that is avoid any unregulated discussion of the survey results. Because a lot of times what we've seen is that the problem with the salary and price surveys is not with the surveys themselves, but what competitors do with the information they receive. Remember I said that the antitrust laws are designed to prevent concerted action by competitors that create anti-competitive harm. And if, for instance, you have some survey data and then you got a group of members sitting around talking about them, there's a greater risk that discussion could lead to an agreement amongst the members as to where to set prices or fees in the future, or where to set wages or other factors that go into price. So it's really important that you try to avoid any unregulated discussion of results. When I say unregulated, I don't mean regulation like we're talking about from federal or state agencies. I'm talking about regulated like in terms of moderators, attorneys, whatever, making sure that, so if there is any discussion, a lot of times, I'm asked to attend a portion of an association board meeting or other meeting where certain sensitive data is going to be discussed, to make sure, A, that, I usually read some statement at the beginning about the basic ground rules and what's off limits and what can't be discussed and agreed to, and also to kind of serve as an antitrust cop to kind of, raise, cut off discussion or something if it goes down a path that it shouldn't go. So if you are going to be having a discussion of this type of survey data, whether it's in person, online, make sure that's regulated by knowledgeable individuals that know how to guide the discussion, certainly starting out with a clear antitrust warning and reminder about what sort of topics are off limits, and making sure that someone's there to monitor it throughout the discussion. And then finally, Karen, last slide of mine is make participation voluntary. So do not require your members to participate in surveys or other and exchanges. Don't require that members' books be audited by the association or by its outside contractor like a Vault Consulting. Make it voluntary. I mean, that's how these things are generally done anyway. I don't know if I've ever even seen one where members are mandated to participate as a condition of membership. But DOJ and FTC say make participation voluntary.
So I have a question, kind of the flip of that. What about how restrictive participation could be? For the couple examples would be, is it only available to members, or do you need to allow non-members to participate? Is there any minimum, let's say, volume requirements, like size requirements for companies in the industry to participate? And the one that I actually have seen, is it available just to domestic participants, domestic producers, let's say, or can importers also participate in the program?
Well, some of these questions are business questions, obviously, but from a legal perspective, I said earlier, let me take your last one first. Yes, you could limit participation, or you could limit distribution of the survey results to participants only if you wanted to, including if you have international participants and domestic participants, but you're only, I don't know why you would only distribute the information to domestic participants. It wouldn't probably make a lot of sense. Could you have any minimum, volume requirements in order to participate? Sure. I mean, because maybe the whole purpose of the survey is to look at companies that have a significant, stake or market share in the particular industry. So if you have a certain minimum, gross sales volume or company size or length of time in business or all of those sorts of things, that's certainly fair game. Could you limit participation to members only and not allow non-members? So this is an issue that we get into, and I've gotten into my whole career in terms of associations I referred to this earlier as a group boycott, sometimes viewed as a concerted refusal to deal. And there have been a lot of cases, court cases over the years involving group boycotts with associations, including some, there was one kind of outlier case involving a realtor association. This is back in the day when the multiple listing service that the realtor associations and National Association of Realtors operates were absolutely essential in order to sell homes, residential homes. You really, nowadays it's very different, but it's still an important vehicle. But back then it was really essential. If you wanted to be a real estate agent selling a home, you had to have access to that MLS. And one of it was a local realtor association said that you could not get access to the MLS system unless you were a member of the association. That case found an antitrust violation, but since then it was kind of an outlier case. What the U.S. Supreme Court has said, most notably in a case called Northwest Stationers, that was a group purchasing co-op. And there was a company that was kept out of the group purchasing co-op. They filed suit alleging that it was a group boycott because the co-op, which substitute association, was a group of competitors that were keeping one competitor from participating. And what the U.S. Supreme Court said, and this principle has been upheld you know, and that case I think was maybe like 1985 or something, and it's been upheld ever since, was that if participation, in that case, the group purchasing co-op, in this case, being a member of the association, or in this particular case, participating in the survey, unless it is essential in order to effectively compete in the market, then there's no anti-competitive harm by keeping someone out. Therefore, there's no antitrust violation. So, you know, as much as associations would love for their information surveys and membership itself, or participation in a trade show, or whatever else to be essential in order to effectively compete in the market, that's just rarely ever the case. Right, a few exceptions we do get into in the association world are things like certification or accreditation, where that's kind of a prerequisite to be an industry player, or we see it a lot in professional associations. To be a licensed professional, you have to be certified or accredited by the organization. In those cases, it is essential in order to effectively compete in the market. But for something like what we're talking about today, that's just, you know, participating and getting access to the survey data is, I can't imagine where it's going to rise to the level of being what's called an essential facility, being essential in order to effectively compete in the market. So, long way of saying, if you wanted to limit participation to members only, that's fine. You know, so long as membership is widely available to anyone who meets the membership criteria, pays the membership dues, etc.
And we've seen that actually be an incentive in some cases to, you know, that's where like the indirect benefits of these programs from associations, as we'll talk about monetization in a second, could be what you get from selling the reports. However, if a lot of times it's a reason that companies may become members, or individuals may become members, to get access to this information and to participate in these studies.
Absolutely. So from a business perspective, yeah, if you can use it, and associations do this all the time. I was working with one last week that was trying to you know, structure their like, I think it was a cost for attending the annual conference, you know, to give a very significant incentive. You know, you can charge member and non-member higher rates for non-members, and, you know, trying to get to convince them to join as a member, you know, by giving a significant discount. If you do that, that's absolutely fine, and that's common and typical.
Right.
All right, that's all that I have on my front, Mike. I know you have
yeah, well, we'll go to, I think there's a couple questions I think that Karen's going to read out to us, and then, yeah, we can go ahead to the next slide too, Karen, because I don't plan to go over all of these in detail. Yeah, I'll go ahead and go through this, and then I think we'll still have some time for you can read off those questions at the end. And obviously, if anyone else has questions, please feel free to add those to the chat. But yeah, monetization, again, there is that hidden benefit, I would say. You know, we've seen studies from ASAE that listed, I think, you know, research and participation in studies like we're talking about as one of the top member benefits. So clearly, in a lot of cases, these types of programs drive up membership dues and the revenue associated with it. However, this comes up all the time. I think every organization would love to have some additional sources of non-dues revenue. So this is a question that we're asked all the time. I wish it was an easier, straightforward answer. I think it varies. The first one I will say, so Vault did a study for the Council of Manufacturing Associations years ago to really just track the different research programs that those organizations were doing. And what we're talking about here, you know, these are your big trade associations that you would think would have ideal output for investors, private equity, industry consultants, you name it. But only about a third of them were actually selling their results. So that kind of like sets at least what we're seeing, like how often that is available. Obviously, for different industries and different types of research, that could change. That first one, pay to participate, I can only think of one or two cases where that is the case. And in that survey itself, it was, I think, under 5% of participants. I think the way we kind of approach this is, okay, there's the clear kind of delineation between participants and non-participants, and if you have a subscriber base that is interested in purchasing your reports. But in addition to that, to me, the opportunities really has to be where there could be some of that value add, whether it's those custom, maybe it's the standard report that everyone gets, but maybe that value add would be with some customized output, interactive reports, you know, things we've talked about already. Having those different tiers and thresholds, it's helpful because then again, you're still giving everyone the same basis, all participants get the same thing. And I guess this is maybe a question for you, Jeff, any concern? So every participant gets the same thing. However, if you want additional feature X, Y, and Z, it'll just be at a premium or come with a cost. I think that's the model.
Yeah, there's no antitrust issues.
Right. Yeah. So again, this is, again, this is another one that could be a whole new, whole additional presentation. There's some pretty good examples that we could get into, but this is a challenge, and I think something. We have some organizations that they can report a hefty amount of revenue, and that your hands may be tied in some regard depending upon the industry and who your members are. There's clearly going to be a different demand depending upon the industry. I think private equity was clearly interested in in the energy sector and other cases that we've seen in recent years. Is there that kind of loop of industry consultants? We see kind of this cyclical loop of we will produce Vault, or companies like Vault produce the industry reports, then consultants will purchase that information, they will do their value add to it, and they will sell that then back to the actual participants. So you never know how it's going to work, but I think there are some opportunities to think through. I think the key thing with monetization is really talking with your members and the participants, what they're comfortable with sharing, because again, if they're I had the extreme example of some clients of ours, they don't even share the results with the association staff. So if they're not even seeing the top level data, then it's probably a non-starter for some of this monetization discussion.
Great, thank you, Mike. Karen, do we have any questions from the group?
Yeah, we have a few. First question is, WSTS has been publishing monthly pricing information since 1977. How is that not a violation of antitrust?
Well, obviously there's not enough detail on that question to answer the question, but I can speculate. Everything I talked about, the safe harbor, is all about publishing price information. That's what it's all about. So the safe harbor and the antitrust laws don't say you can't publish price information. They give you a 5-step process, though, that you need to follow in order to safely do it without violating the horizontal antitrust laws, including things like having at least 5 participants, aggregating all the data, making sure no participant constitutes more than 25% in any category, making sure the data is at least 3 months old, having a third party manage the collection and analysis and dissemination process, making participation voluntary. So, pretty much ran through all of the steps of the safe harbor. If you do that, you can publish price information, but it has to be done, if you want to stay within the safe harbor, within that construct.
I'll just add, I think I know who asked that question, but WSTS is the World Semiconductor Trade Statistics. That's not something that Vault's involved with, but for those interested, especially in that monetization aspect, it's literally just Googling that or reaching out to me afterwards. They've got a very robust program that I know we've had other groups of ours kind of look at and hoping that they could emulate.
Okay, here's another one. In the case of association research outsourced to a third-party firm, is the third-party contractor also liable, penalized for antitrust violation? And if an association client is willfully ignoring antitrust concerns raised by the third-party researcher, would it be reasonable for the firm to end the contract on those grounds?
So, first off, I mean, the third, certainly antitrust violations like this are the Sherman Act Section 1 refers to a conspiracy, meaning, it sounds kind of nefarious, but what it basically means is that anyone who's involved in an antitrust violation, even if they're not an industry competitor, could be association staff, could be an outside vendor. If that vendor is involved in that conspiracy to fix prices, that vendor certainly can be held liable for any antitrust violations. Now, in general, that's going to be something that we just don't see. There's no incentive or reason for Vault Consulting, to want to perpetuate some sort of an antitrust conspiracy and antitrust violation. And generally, it's quite the opposite. And generally, associations are using companies like that to help mitigate antitrust risk, to make sure that proper steps are being followed, there's proper independence, that the actual member companies are not involved in seeing the data and all of that kind of good stuff. But theoretically, there certainly is always a possibility that anyone who is involved in facilitating or participating in that conspiracy can be held liable under the antitrust laws. And I think the other part of your question was if like the association, if the company like Vault is aware that the association is kind of being, it's going to be rare to have like an intentional violation of the antitrust laws, although we've certainly seen it. But even if they felt like the association is just being negligent, they're not following these guidelines. They're potentially providing access to raw data to industry members and whatnot. Should the company terminate its relationship with the association? I'd say probably. Yeah, for the reasons that I just answered in question 1, it doesn't want to be drawn into any antitrust violation. But again, that's a rare situation that I don't think Mike or I probably have ever seen.
And I'm sure it's common to other third parties like Vault. Our contracts, of course, say, the information that Vault receives is only used for the purposes of the association's reports. It's not that we have this information and we're using it elsewhere. That would be a clear violation of our contract.
Okay.
So we probably have time for probably one more question. We do a salary survey every year. We assume most salaries are updated January 1st. If we release the survey results at least 3 months after January 1st, like April 2nd, can we ask what their salary rates are on January 1st, or is that considered current information?
So the way the safe harbor rules are written by DOJ and FTC, it says that the data that's being collected needs to, the price and wage data, which would include salary information, has to be at least 3 months old from the time the participant provides the data. Now granted, what you're describing, what the questioner is describing, would seem to have the same effect, right? By basically collecting current data, but not releasing it until 3 months later. But that's not the way the safe harbor is written. So if you want to stay within the safe harbor, you should be asking participants to only provide at the time they submit the data should be at least 3 months old. And can I sit here and tell you that if you do it that way, the way you described it, that it's an automatic price fixing violation? Certainly not. But it would be a less prudent way to do it. All right.
All right. Well, thank you everyone for joining us today. If you asked a question and we weren't able to get to it, I've included the speakers' email addresses on this page. So write it down and shoot them an email, and they'll certainly answer your questions. But thanks again, and you'll receive the recording pretty soon in your email.
Thanks everyone for your participation, and thanks to Mike and Karen involved for hosting us today.
Yeah, thanks, Karen.
Thank you.